Morning, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin Kerrigan. And in this vlog today, I'm going to be talking about adult children that take advantage of you and what your options are. So we're going to be talking about the possibilities of what to do if they're still living with you and they're in their 30s and 40s or even 50s, and what to do with your estate and how to handle any loans or anything else that you loaned to them that they haven't paid back. We're going to talk about that in today's vlog. First, one thing I'm talking about is there's a situation, there are circumstances upon which adult children live with you and it's mutually beneficial. And I'm not talking about those circumstances. There's some wonderful situations upon which the child is taking a hiatus in their normal life. They're sacrificing for their parents. One of you or both or one of the parents needs a lot of help, and that person is there to help out with that, to help with the food and the keeping them out of the assisted living facilities. And they're doing this out of love and as a family, and that's wonderful, absolutely wonderful. And that's obviously to be encouraged. I'm talking about somebody, an adult child, taking advantage of you and what your options are. First, if they're an adult child and they're past their 20s, maybe you give them some time to get themselves established. Maybe they're going into higher education in graduate school and they're living with you. I'm not talking about that. I'm talking about when they're in their 30s and 40s and they're still down in the basement apartment playing computers, and they don't want to work anywhere, or they want to work part-time because they got mom and dad paying for them. In that situation, if you want to get them out and they're unwilling to get out, there is something called in New Hampshire called a shared facility arrangement for tenancies. It's a lot easier to get somebody out in that situation. I would still recommend in that situation, since there is a court process, that you still hire an attorney. In the cases that I've had with this, the child that's living there is often fairly manipulative, and they're also very smart, and they figure out ways on the internet to figure out arguments of defenses that they try to throw up in court. And if you're there without an attorney, you can't pivot and address those comments and arguments by the child who wants to just continue to get free rent from you, and they need to be out. And sometimes that tough love is necessary for them, and I'm happy to help with that. Or other lawyers are happy to help with you in regards to that. But take a look at that. Shared facilities under the New Hampshire Landlord Tenant Statute, you can force them out. If they're in a situation where they either they're living with you or not living with you, but you've given them gifts during your lives, or you've given them perhaps loans. The loans are difficult. Generally, I recommend not giving loans to your children unless you're thinking about them as a gift, because if you're not going to be collecting them, it's awful tough. If you don't have an exit strategy in any loan, you shouldn't be a lender, because you always should be able to figure out what you're going to do in regards to that. So if you can't do that, if you have a loan with them, for one, get a promissory note. If you do it, I still recommend against it. But if you do a loan in a situation, do a promissory note. I have had clients that have had that paid a loan, and they file a promissory note, and they even have a second mortgage on a house so somebody can facilitate the purchase of the house. In the right situation, that can work perfectly. But if it's somebody that's just going to be looking to borrow money from you and they're not going to be able to pay, obviously you want to think about that very carefully, but at least put it into a promissory note, and a lawyer can help you in regards to that. Lastly, what happens when you're thinking about your estate plan? You have 3 children. Your daughter or son, one of your daughters or sons has been getting a lot of gifts or loans from you during their lifetime. How do you deal with it? It's certainly your money, and you decide what to do with your options. Obviously, if it's you're a married couple, you're probably providing for your spouse, and then it's the surviving spouse that's going to be dealing with this issue. But in that circumstance, you don't have to split it 3 ways. You can have a will or a trust that has a situation where you identify the child, and you state in the will and or the trust that you provided for this child during the life, and you're not providing anything more. Or if you're concerned that they might take a shot at the other siblings and try to challenge the will and say that there's some undue influence and you want to prevent that from happening, you can do what's called a no contest clause. And a no contest clause, also called an interim clause, is one that if you challenge the will and the trust and you're unsuccessful, you get nothing. Now, of course, in that situation, you have to put something in that they have something to lose. By way of example, say you have an estate that's worth over $1 million left, and you're leaving approximately $500,000 to two of the siblings. You can leave $50,000 to this child that you don't want to get anything, and you put a no contest clause in, then they have real skin in the game. Because if they challenge it and they lose on their interim, they lose $50,000. Put $5,000 in there or some other insignificant amount, they're going to say, why not roll the dice? But if they're looking at this and they're saying, okay, my siblings, I can make these allegations against them saying that they unduly influenced my parent, and it's going to be a tough battle, but I can make those arguments. But if I lose, and I get $50,000 lost on that. I'm going to be thinking twice before I do that. And that's why you have interim clauses. You want to have them to have skin in the game. You got to put enough money up there for them to lose. And don't do $5,000. $50,000 is a good idea. You can talk to your attorneys depending on what you have for an estate in regards to that, but that's a possibility. And then sometimes people just won't even put an interim clause, and they'll just specifically spell out that person, and they'll say what the reason is that you're not providing for them. If you do that, and you can do that, and if they challenge, they can challenge and not have any repercussions if they don't have an interim clause, but still they lose ultimately on that if you've done everything the right way. I'm Dan Marr at 603-883-5501, 603-883-5501. I'm happy to help you if the opportunity arises, and you can also check out our website, naturallaw.com. That's naturallaw, one word, .com. And you click onto my bio and then to my weekly blogs. They're all by topic, and you can review any of them that are of interest of you. Again, Dan Marr, 603-883-5501. Thank you.